Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3098. United States of America versus Calvin Smith, also known as A.S.A. Appellant. Ms. Van Pelt for the appellant, Ms. Kelly for the appellate.
Good morning.
Good morning, Your Honors, and may it please the court. Libby Van Pelt for Calvin Smith. I'd like to reserve 2 minutes for rebuttal. The government has conceded error on count 1, the drug conspiracy, where the district court sentenced Mr. Smith to life, even though that sentence was admittedly above the statutory maximum. This error alone requires remand to the district court for a full de novo resentencing hearing. The government has also conceded error with respect to counts 19 and 20, where the district court sentenced Mr. Smith on both, even though the parties agreed that was unconstitutional and in violation of the double jeopardy clause. A number of other issues arose at this resentencing, and I'm going to start by addressing those that pertain to count 3, the RICO conspiracy. With regard to that count, the district court committed a cascaded series of errors. First, he sentenced Mr. Smith under the incorrect assumption that count 3 carries a mandatory sentence of life. And I'll explain how we know that based on the context and also the actual words that the district court both spoke and wrote. Second, and relatedly, even if he had not been laboring under that incorrect understanding, he still failed to consider, as is required by statute, Mr. Smith's individualized characteristics, which were quite compelling in this case, and otherwise erred in how he considered the evidence before the court. Third, the district court improperly considered conduct associated with counts 4 and 5, the vacated counts, even though the court failed to make a factual finding that that conduct had been proven by a preponderance of the evidence or otherwise. And in fact, there's no valid basis upon which the district court could so conclude, given that they were vacated on a fundamental ground that renders them unreliable, ineffective assistance of counsel, and also how the district court characterized the evidence in its written ruling following the ineffective assistance of counsel hearing. Of course, if I don't...
Can I ask you about counts 4 and 5? So what was the precise objection that was raised? Is it that Mr. Smith did not commit the underlying conduct, or was the objection simply to considering the vacated offenses?
To both, Your Honor. At a sentencing hearing, in order to consider relevant conduct, the district court has to find, after the government proves that beyond a preponderance of the evidence, the defendant actually committed that relevant conduct. In this case...
Was that objection made below clearly that way? I mean, there are a number of places where it seems that the objection may be simply to considering the vacated conduct and not whether that conduct was in fact.
Yes, Your Honor, that objection was made fulsomely. If you look in the sealed appendix, which contains the pre-sentence investigation in this report, I was counsel below with regard to the resentencing hearing, and there was a fulsome objection there. In fact, I went back to the actual trial transcripts from 2002 and pulled the evidence from that trial transcript and submitted to the court. Here are the findings you should make and why you should not consider counts 4 and 5, because it's inherently unreliable, right? So that objection was fulsomely made. I also then submitted separately from the pre-sentence investigation reports a detailed sentencing memorandum in which I renewed those objections. And then twice at the sentencing hearing, I also raised the issue.
Thank you.
And so I think there's well, actually what I'll do is I'll return then to our first issue, which is that the district court sentenced Mr. Smith on count 3, the RICO conspiracy, under an incorrect assumption that it carried a mandatory sentence of life. And I said earlier, how do we know that? We know that based on context and then the actual words that were said and written by the district court. So I'll start with the context here, which I think is important. Mr. Smith's original sentencing was held back in 2005. He was jointly sentenced with 5 other co-defendants. Each of those other co-defendants was subject to a mandatory life sentence. So the district court sentenced those 5 to life, and then also at the same hearing sentenced Mr. Smith to life after a very brief allocation by his attorney, the same one that has been found ineffective. That attorney failed to ask for a sentence of less than life, even though one was available. At that time, the district court provided no discussion whatsoever of the 3553A factors. He just pronounced sentence. Now, at the resentencing in 2024, the district court referenced that earlier sentence when he said, I must and shall adhere to my prior decision and resentence Mr. Smith to life. So given that context, it makes sense that the district court was coming into this sentence, this resentencing hearing, with mandatory life sentence in his mind. Okay, so then we get to the hearing and what he said at the hearing and what he wrote afterwards. Everything at the sentencing suggests that he was laboring under this incorrect assumption. Or the flip side of that is there's nothing in the record that shows that he understood that a sentence of less than life was available. So I have 4 different things that he said and wrote that I'd like to go through.
If he thought it was a mandatory life sentence on count 3, how do you explain his discussion of why he's not departing downward? If it were a mandatory sentence, he would have no reason to even consider departing downward.
Well, I don't think there was a discussion ever about departing downward. He did recite some of the 3553A factors. Remember that count 3 was just one count upon which the district court was sentencing on him. And even if a count is mandatory life, the statute still requires that the judge.
Appendix 994, he responds to the suggestion to mitigate downward by saying that it suffices that Mr. Smith has not one but multiple convictions today, any one of which would be sufficient to sustain a life sentence. That remark and the remarks that follow are inconsistent with the idea that he thought the life sentence was mandatory.
I think actually that is the opposite, Your Honor. So if we start at the very beginning, the outset of the sentencing hearing, the district court announced there, I am going to, Judge Lambert said, I am going to sentence Mr. Smith above the statutory maximum on count 1, the drug conspiracy. And I quote, because Mr. Smith has multiple other convictions that call for life sentences, the court sees no reason to alter its prior sentence on this count, which is similar to the language that Your Honor just recited. Now, importantly, the only other conviction that carried the possibility of a life sentence was count 3. So the fact that you have the district court at the very beginning of the hearing, before we have argument, before we have allocution, saying that he's going to get life on count 3, so it doesn't matter if I give him life on count 1, 2, that statement assumes that the district court knew at the beginning of the hearing that he was going to give Mr. Smith life on count 3 and that he thought he had to. Okay. The other alternative is that
these remarks seem to me significant in another respect. He was refusing to depart downward because Smith had multiple life sentences. Now, or after this hearing before us, he no longer has multiple life sentences. He only has one. And so the reasoning that Judge Lambert gave for not departing downward no longer exists.
Well, I'm not sure I may not understand the question. But at this resentencing hearing, it was a de novo resentencing hearing. He was resentencing Mr. Smith on all of the counts.
Right.
So, and the only count for which a sentence of life was available was count 3.
Right.
So
None were required. There was no required life.
no life required, it was simply available. I'd like to point,
I think if I understand Judge Randolph's point right, it's that he had previously said there's multiple life sentences and that had influenced his sentencing decision. But in fact, I think Judge Randolph is pointing out that that was no longer accurate by this hearing, right?
Right.
correct. Yes, Your Honor, that was no longer accurate. And so that language, given that it was inaccurate, suggests that he did not understand that count 3 did not in fact carry a mandatory sentence of life. And Judge Randolph, I'd like to,
But he said, I'm sorry, go ahead and respond.
Judge Randolph, if you look too at, again, the outset of the hearing, the district court stated both the guidelines and the statutory provisions. And so the court said the statutory provision for count 1 is 10 years to life. Also recited the statutory provisions for the other counts. Then it said twice, the statutory provision for count 3 is life. And again, the statutory provision for count 3 is life. So for the other counts, he gave the sentencing range available to him by statute, right? The mandatory minimum up to the maximum authorized. But for count 3, he just said life, suggesting that there was no range because the only available sentence was life. And as someone who does these cases in the trial court, that is how you say it when it is in fact a mandatory life sentence. So that's another thing he said at the sentencing hearing that suggests that he was
What did he say
laboring.
in his written explanation for the sentence?
So in the written explanation, and that's at sealed appendix 63, he uses language that's similar to what he said at the outset of the hearing. He says, well, I'm going to sentence him on both counts 19 and 20 because, quote, Mr. Smith would have received a life sentence anyway on counts 1 and 3. And then separately on that same page, he writes that he was reimposing life on count 1, even though it was above the statutory maximum, quote, because he would have received a life sentence anyway on count 3. So that suggests, again, that the district court is thinking about the sentence for count 3 as mandatory. Otherwise, you simply would not say and write, I'm going to give him life on count 1 because he's getting life on count 3. Anyway, if count 3 is not mandatory life, that reasoning simply does not make sense. And also the verb tense, right? He didn't say because he received life on count 3, he would have received it. The other place in the record where the district court makes statements that suggests, again, that he thinks count 3 is a mandatory life count is in the record in the appendix at 994, the same page that you referenced, Judge Randolph, where the district court says, in order to communicate that our society simply will not tolerate such terrible acts, no matter what the personal circumstances of the person committing them, this court must and shall adhere to its earlier decision and resentence Mr. Smith to life in prison. Must and shall are command verbs that create non-discretionary sentencing outcomes. Federal courts treat them exactly the same and they treat them that way. So if you look at statutes, if we take the word must, the Armed Career Criminal Act uses the word must to impose a mandatory minimum sentence. It says in the case of a person who violates this section, that person must be in prison, not less than 15 years. Also, if you look at this.
Totally consistent with him thinking that because of the nature of the offense and other factors that I've got to sentence this guy to life, because otherwise I don't communicate to society how grave and how horrendous this criminal act was.
But that's not what he said. I would agree with you if the district court had said, after considering all of the 3553A factors and looking at Mr. Smith individually, this crime outweighs all of those other factors such that the only appropriate sentence is a life sentence. But that's not what he said. He did not say he was exercising his discretion and that was what he had decided.
Right after the statement that I just said, or the statement that I was just quoting and you were, followed immediately after he said the sentence was warranted because of the nature and circumstances of the offense.
That's consistent. that is consistent with it being a mandatory life sentence and the district court imposing a mandatory life sentence. There's no inconsistency whatsoever there. And also I'll note that
There
statement.
is inconsistency when he continues and says it's also warranted because of the history and characteristics of the defendant. If it's mandatory, the characteristics of the defendant don't matter.
Well, you're still going to get a mandatory life sentence on that count, but you still have to follow the statute and recite those. And I'll also note, Judge Randolph, that in that sentence, the must and shall sentence, if you will, the district court was not specific to Mr. Smith. What the district court said was that for this particular crime, the court must and shall impose a life sentence regardless of the individualized circumstances of this defendant. That, again, is a judgment that Congress makes, right? Because Congress has various statutes that impose a mandatory life sentence where we have Congress telling the courts, don't consider nothing. For this particular crime, no factor can outweigh the seriousness of this conduct. And so we're going to impose a mandatory life sentence.
Okay. Do you have any more questions? Great. Perfect. Thank you. We will give you your time for rebuttal.
Thank you, Your Honor.
Hear from the government now. Ms. Kelly?
Thank you, Your Honors. Catherine Kelly on behalf of the United States. Your Honor, in this case, the government has conceded that there was error in regard to sentencing on count one, the life sentence on the narcotics conspiracy, and that it is necessary to vacate count 20 due to merger principles, but that it does not require resentencing. It can simply be done
Count
by.
one requires resentencing.
Correct, on count one itself. But beyond that, though, there's
This judge was looking at sort of the whole picture of all the sort of multiple life sentences that were out there. If you actually vacate one of those life sentences.
well, the court.
Doesn't that?
I'm sorry.
That suggest, sorry, I wasn't quick enough on the draw there. Doesn't that suggest that it would be best if the district court could go back and just consider the sentencing on, again, in light of both those changes?
I don't think
It seems
it's.
to be synergistic in the sentencing process, and that's sort of how it's supposed to be, particularly with 3553 factors. But when you have a judge who said many, many times, look at all these crimes, look at all these life sentences, and then if it turns out there's no mandatory life sentence at all, the one that he thought was life was capped at 40, and another one of those life sentences that disappeared. Why wouldn't it be fairer to the district court judge to just leave it to that judge to decide whether that vacature makes a difference? He could say it doesn't. It just seems to me it's fairer to the district court judge to let the district court judge look at the whole picture on remand rather than tying his hands.
I mean, the court certainly could do that, and we're not saying that it
There's
couldn't.
nothing
We
wrong
were
with
just
doing that.
There's nothing wrong with doing it. We would just say simply, particularly because none of the other errors that defense counsel has raised were raised to the court. Most of the other arguments were on plain error review.
I'm not sure that's got to do
There's
with it. I think you
there's really no reason.
Conceded plain error on count one, and count three was preserved. There are objections to count.
We conceded error on count one. That argument was preserved at the resentencing.
I'm sorry, you're right.
But the others, in particular on count three on the RICO conspiracy, we don't believe was preserved. There was no indication during the resentencing hearing that defense counsel was concerned or was presenting an argument notifying the court that it believed it was making an incorrect statement, that the court was indicating that both the mandatory maximum under the statute and the mandatory minimum were life. So given what the court actually said, and particularly what Judge Randolph has pointed out in regard to the court not needing to say that it wasn't going to depart from the guideline sentence of life if it truly believed that there was a statutory requirement that it be life, there's just, given those statements, there's no reason to believe that the court made any errors on count three.
The count, sorry, and correct me if I've got this wrong, but the count three one, for the RICO conspiracy to become life depended on the judge's reliance on the Dent murder. Is that correct?
Actually, no, Your Honor.
Did I have that wrong?
In footnote 25 of the pre-sentence report, it says that even if you take out the Dent murder and CCE murder, counts 4 and 5, that it had no overall effect on the total offense level, which was
He
43.
said he was relying on the Dent murder. He said that.
He said he
was
considered
relying
it,
on.
but
He said that's what he was relying on, and the only relevance would have at this point would be to bumping count 3 up to life, correct?
I believe the way the court framed it, he was talking about it at the beginning of the resentencing, defense counsel raised 3 objections that the court ruled on. One of them being that the court should not consider in any manner the Dent counts 4 and 5. And the court said in a generalized statement that it believed under United States versus Watts that it could do so. And
Yeah,
that
I'm not being clear about my question. I
I'm sorry.
apologize. Where in the record, as I read the record, he was relying on the Dent murder to get this up to life. You have to find something to move it up to life under count 3. The only thing I see discussed is the Dent murder. Is there a place where he said he was relying on something else to bump that up to life?
I don't recall there being any particular statement about what he was using particular to count 3.
Do judges need to identify the basis on which they are determining that this RICO conspiracy count is now a RICO conspiracy count in the category that's eligible for life sentence? It wouldn't otherwise be.
Right,
You
right.
have to identify that, right? They have to.
I believe so. There were numerous RICO acts, racketeering acts.
I understand, but the one that he pointed to, and that means a lot, where this is, the judge is the one that's there. The judge gets the discretion. The judge is the one making this decision. And the only thing he relied on was the Dent murder, correct?
I just see that would have been an item that the court relied on. However, I believe that this court statement was more general because I was talking on page A948, which is where this was briefly discussed.
I'm asking what not what we said. I'm asking what the district court relied on, and it was the Dent murder. And we haven't been able to find anything else, correct? So the district court said he was relying. District court had to identify the basis. District court pointed to the Dent murder. That's what we got.
That we do have that, but we also have the PSR statement that even without consideration of the Dent murder, that those, the total offense level for the RICO conspiracy would not raise. I can get the court's quote.
I understand, but the PSR is not making the decision. The judge is making the decision.
No, it's not.
The judge is to identify it. So I understand the point you're making, but the judge didn't do it.
But the court did accept, as did the parties, and the parties agreed that the total offense level for the RICO conspiracy was indeed 43.
Is it the offense level that bumps up the RICO conspiracy charge, or is it the identification of a particular racketeering act?
Actually, the PSR, Your Honor, says that racketeering Act 22, which was the Dent murder,
Yes.
was used in paragraph 145. It's
Right. So
however, the court did say, or not, I'm sorry, I'm misspeaking. The PSR did say that the removal of counts 4 and 5 in racketeering Act 22 would have no overall effect on the total offense level.
right, but that's because I assume the PSR was assuming you can consider Dent anyhow, the Dent murder anyhow, which he talked about, right?
No, it says, however, should the court determine racketeering Act 22 is also invalid, racketeering Acts 1 and 9 would be grouped with another of the murder racketeering acts, and ultimately the total offense level for all of the counts would not change. It would remain 43.
Okay, so I think that's a different point. So what I'm trying to focus on here is, I thought you agreed the district court needs to identify a racketeering act as the basis for upping that sentence to the life range. Right, the statute says if you find, then the cap is life, correct?
I believe so, Your Honor, yes.
Okay, and the one the district court identified, the PSR identified, was the Dent murder. And when it was suggested that you shouldn't rely on the Dent murder, the judge said, no, I can rely on the Dent murder even if the count is vacated. Right?
Correct.
That's how the
Correct.
sentencing proceeded. But I thought it was also pretty crystal clear that the judge, when there's an acquittal, the judge has to find that the murder occurred by a preponderance of the evidence, correct?
Correct, but
They
there's no,
can do it. They can do it, but they have to find where in the record did Judge Lambert find by a preponderance of the evidence that Mr. Smith committed the Dent murder?
it did not specifically state at any point that it was finding by a
Did it make
preponderance
a
of the
finding
evidence.
or not? It's a yes or no?
It did not.
question.
It did not
Did
make a
not make the
specific
required
finding.
finding to rely upon that. Okay, thank you.
However, I would also say that this was not an issue that was raised at the hearing. The defense counsel never asked for a specific finding, and that you can also tell from the ineffective assistance of counsel decision that.
No, I'm talking about this resentencing.
No, I understand, Your
Second
Honor, but
sentencing.
I don't think that there is any question that the court could find that. So,
But didn't.
but did not,
Okay.
yes. So, as to
Is that a
the,
plain error?
I believe it would need to say that specifically.
Okay.
But beyond that, there's certainly no question in the additional points defense counsel made that the court considered Mr. Smith's personal circumstances. It specifically said that. The court made statements that it had clearly considered his circumstances. It acknowledged expressly that it was required to consider the 3553A factors, including the history and characteristics of the defendant. It acknowledged Mr. Smith's plea for leniency. It recognized that he was youthful at the time of his offenses, and that it was arguable that his disadvantaged home life led to his criminality and his rehabilitation and so forth. But it understood that it was impossible, as the court said, when it weighed those, to overstate the gravity of Mr. Smith's offenses, that he was deeply embedded in the drug trafficking conspiracy that claimed many lives and helped to aid the district's status as a murder hotspot. So the statement that it must and shall impose a life sentence, no matter what Mr. Smith's personal circumstances were, is out of context. The court, even before making that statement, was talking about all these factors that it recognized and had considered. And the fuller statement, the court was saying that it was to communicate to our society that it will simply not tolerate such terrible acts, no matter what the personal circumstances of the person committing them. This court must and shall adhere to its earlier decision and resentence Mr. Smith to life in prison. That is certainly not a reflection that the court was laboring under a misunderstanding that it was statutorily required to just simply resentence Mr. Smith as it had in the past. The court definitely considered his rehabilitation.
Sorry.
Although we have not gotten into it, we certainly believe that Judge Lambert is the most appropriate judge, particularly considering his lengthy history with this case, to resentence Mr. Smith.
Thank you.
Thank you, Your
very
Honor.
much, counsel. We will give you 2 minutes for rebuttal, Ms. Van Pelt.
I recognize that this is not something that your honors are doing routinely, but in this case, I think reassignment is appropriate. Looking at the Wolf factors, the court does not have to find that Judge Lambert is biased or incapable of doing a third sentencing hearing in accordance with the law, or unable to put out of his mind the lengthy history with this case and all of the various co-defendants. Even setting all of that aside, fundamental to our judiciary is public confidence in the impartiality of judges and the proceedings over which they preside. And so I think the delay in this case is significant. And maybe one of the most important cases in my brief is the Hernandez case, because it bears so many similarities to the case that we have here. That's also a case where the Second Circuit remanded a case to a district court to hold a hearing, and the district court waited over 10 years to hold that hearing. And then when it held the resentencing hearing, it again committed errors. In that case, the Second Circuit took an additional step of reassigning the sentencing for 3 reasons.
Some of the delay here was not due to Judge Lambert's delay. There were delays that were a result of the reassignment of counsel and other things. Some of the delay may have been the district court judges, but certainly not all of it, or maybe even the lion's share of it.
Well, I think it was the lion's share. So for instance, Mr. Smith filed a 2255 out of an abundance of caution in 2014, noting that Judge Lambert, we still need to hold this ineffective assistance of counsel hearing. The district court did not rule on that motion for 7 years. It took the district court 7 years to rule that that motion was premature. At another point, Mr. Smith's counsel filed with the court a notice that a hearing needed to be held, and the district court did not act on that filing for over 3 years. At one point, Mr. Smith's counsel filed a motion to withdraw, citing a conflict. The district court did not rule on that motion or appoint Mr. Smith another attorney for a year and a half. So I think there were delays to even do like routine, simple things in this case. And so the question then becomes, returning to what the Second Circuit decided in Hernandez. There's a couple reasons why, just for the appearance of justice, right? There were dozens of people in the courtroom at this hearing. There will be going forward. An objective observer might question the judge's impartiality given this gap. And so Judge Calabresi in the Second Circuit wrote, when a judge has, through a combination of the judge's own inaction, of some government neglect, and Judge Rao perhaps of the prisoner's lack of complaint, failed to act for some, in that case, 15 years, an objective observer might question the judge's impartiality, regardless of the result the judge ultimately reaches. And the judges in that case then talk about, even if the defendant is then sentenced below or the same or above what the original sentence is, an objective observer could still walk away thinking here that this is not how we should conduct court proceedings in this country. So,
Any further questions from my colleagues? Okay. You want one sentence to wrap up and then?
one sentence, Your Honor. Life is an extraordinary sentence. It means a denial of hope. It means that good behavior and character improvement are immaterial. It means that whatever the future might hold in store for the mind and spirit of the convict, he will remain in prison for the rest of his days. Mr. Smith deserves a fair sentencing hearing. Please vacate his convictions and remand to another judge.
Thank you very much. Ms. Van Pelt, you were appointed by this court to represent Mr. Smith in this case, and the court thanks you very much for your assistance.
Thank you, Your Honor.
The case is submitted.
Case number 25-7003. Mohammad, Hilmi, Nassif and Partners, owner of the trade name Trust Worldwide Corp. Appellant versus Republic of Iraq and Ministry of Industry and Minerals of the Republic of Iraq. Ms. Ortiga Gomez for the appellant, Mr. Zubairi for the appellees.
Good morning.
Good morning. May it please the court. The lower court erred with respect to Iraq's explicit waiver of sovereign immunity because it broadened the plaintiff's burden of production and it shifted the burden of persuasion to the plaintiff. Now, the court acknowledged that Nassif's proof consisted of declarations that paraphrased discussions between high-ranking Iraqi government officials and Nassif and Partners. But even with that acknowledgement that the declarations did not contain quotes from what these officials said, the court still attempted to analyze the words that were used by the Iraqi officials according to the declarations. And that led to the court failing to do what it was supposed to do under the FSIA, which is to determine the sovereign's intent. Now, if we look at the content of the declarations, these high-ranking government officials in these discussions with Nassif and partner were assuring Nassif and partners that it needed to sue in order to collect, and that when it sued, Iraq was not going to defend and it was not going to object.
So perhaps these statements could be suggestive in one sense of, some type of waiver of sovereign immunity, perhaps. But it seems there are other plausible interpretations as well. And so the standard is really difficult because the Supreme Court and this court has repeatedly said that any ambiguity has to be construed in favor of sovereign immunity. So how do you overcome that high hurdle? So it's not enough that the statements could be read as a waiver. If there's any other plausible interpretation, then this court's required to rule in favor of sovereign immunity.
Your Honor, I would posit that there is no other reasonable interpretation given the context in which the statements were made. These were not statements that were made at a time when the parties were negotiating the letter agreement. These statements are made when that letter agreement has already been breached. And the discussion is about what are we going to do in order for Iraq to pay? So the discussion is, what are we doing considering that the letter agreement has already been breached? So all of the discussions that are taking place are contemplating a lawsuit because Iraq is saying, to collect, you're going to have to go get a judgment. And when you bring us the judgment, we'll pay it. But don't worry, because we're not going to raise any objections and we're not going to defend. So
maybe that means they're not going to raise any objections on the merits. There's no claim in the declaration that they said that they waive their sovereign immunity or that they won't raise immunity. I mean, immunity and the merits are arguably distinguishable.
There's no requirement in the law that the word sovereign immunity be used in order to explicitly waive it.
That's true.
And in this case, the saying we're not going to raise any defense, I mean, what greater defense, what more obvious defense does a sovereign have other than sovereign immunity? So a reference to we are not going to defend is a reference to we are waiving our sovereign immunity. And that really is the only reasonable interpretation that can be given to these statements in the context of a letter agreement that's already been breached and the parties are discussing how are we going to collect on that breached letter. It's going to be through a lawsuit because that is an encouragement to sue. Iraq says to collect, you go sue. That's an encouragement to sue. How do you encourage a party to go sue, couple it with assurances that you're not going to defend, you're not going to object, and then turn around and say, oh no, but we are actually asserting our sovereign immunity. It's inconsistent, they're irreconcilable. And we know what the court then did is it focused because it was trying to read the exact words that were in the declaration, even knowing that those were not the exact words that were uttered by the Iraqi officials. It then said, well, it found fault with our proof. It said, well, the proof is just too ambiguous. It lends itself to ambiguity and says we can't precisely determine whether there was an intent to waive. But this precision requirement that the court discusses is not found anywhere in the law. It was found in Iraqi's brief. If you look at the district court's decision, the citation is to Iraq's brief when it discusses precision. And we know that the law doesn't require.
It's just another way of saying an absence of ambiguity.
Yes, Your Honor, but.
Okay, so we have to have an absence of ambiguity. You agree with that?
Yes,
right?
I do, Your Honor.
And you've quoted some of the language, but none of the language is quotations from government officials. It's paraphrases. It's someone's, here's what I remember them saying.
Yes.
Isn't that itself a source of ambiguity? Because, and by the way, I assume this has all been translated as well.
Yes.
Right. So it's a translation of someone else's hearsay statement. Isn't that itself just a source of ambiguity because we don't have their words specifically?
Your Honor, there is no specific wording requirement in the FSIA that is akin, that is tantamount to a writing requirement, which the FSIA doesn't have.
No, I'm not. I don't think that's fair to confuse that with a writing requirement. What I'm saying is we don't have the Iraqi officials' words, full stop.
Yes, Your Honor.
We don't have their words. isn't the absence of having their words, their own words, make it ambiguity? All I've got is someone's recollection of those words.
And Your Honor, what I'm explaining is that in this context, right, where the discussion is solely centered on a breach of the letter agreement and a lawsuit, the court can look at the message that is being conveyed by these officials without knowing the exact
The
words.
message without the words is an unambiguous waiver.
When the message is sue, we will not defend, we're not going to object. Yes, Your Honor. And we know that the law doesn't require these precision.
It's someone else's statement that they told me they won't defend, they won't object. And since what they meant by that, as Judge Rao was pointing out, is really important.
Yes, Your Honor. And
So then exactly which word they remembered someone saying matters.
it does matter, Your Honor, but again, in this context where the facts are uncontroverted, we're not dealing with a case where Iraq has come with its own evidence and said we didn't utter those words. So in this scenario, what the law requires, according to Owens versus Sudan, which is a DC District Court case that relies on Simpson, a DC Circuit case, the law just requires that there be sufficient proof and even a meager showing by a plaintiff when the defendant hasn't brought forth its own evidence is sufficient. This is a motion to dismiss stage. Now, at a later stage, Iraq will have the opportunity to introduce whatever evidence it wants and can raise the issue again. But at this initial stage
It's a
where,
little different. This is jurisdictional.
yes, Your Honor, but again,
Jurisdictional, and so courts can actually gather some factual evidence and make some factual findings
and
at this stage.
yes, and the law allows Iraq at this stage, which is it's very awkward, very unusual at a motion to dismiss stage for a defendant to have the ability to produce its own evidence. And yet Iraq didn't do that. And so the law says that even a meager showing in Simpson, this circuit court warned that a defendant who doesn't bring its own evidence risks the denial of a motion to dismiss because even a meager showing by the plaintiff will suffice. And here, Your Honor, I would argue that this is more.
Showing, but then you have to weigh that against the fact that you have to have clear and unambiguous evidence of a waiver of sovereign immunity. So how do you
reconcile those? And Your Honor, you reconcile them because again, the message being conveyed generally is just completely inconsistent with an assertion of sovereign
Generally is not
immunity.
enough in this context. So even if, say we think that your interpretation is 90% likely, the fact that it's even plausible that there's another interpretation is sufficient under the case law to defeat, to require us to recognize Iraq's sovereign immunity.
Even if we talk about the plausibility of a different interpretation, as the district court judge did, the district judge said, well, they could have been speaking about the letter agreement, not the lawsuit. But again, they weren't speaking about a venue limitation in a letter agreement devoid of the lawsuit. You just can't separate those two because in this context, that letter agreement had already been breached. So we are just talking about what is your remedy to collect on this breached letter agreement? And Iraq says in whatever words it used explicitly, the message was go sue. And we're not going to defend.
Go sue, but that doesn't mean they won't assert a defense of sovereign immunity.
Well,
go sue. Maybe it's just a delaying tactic. There's nothing in the declarations that it's inconsistent with. Even you want to say it's bad faith or whatever, there's go ahead and sue, but whatever, we're going to assert sovereign immunity. That is the nature of sovereign immunity.
But Your Honor, taking the declarations in the as true because they're uncontroverted, it's a motion to dismiss, were the plaintiffs, taking those declarations as true, Iraq also said that they were not going to defend on that lawsuit. And they said, once you get the judgment, we'll pay on it. So under those, Your Honor, I would submit to this court that given in this unique scenario, there is a clear and unambiguous waiver, and especially considering that we just have to have meager evidence. And I think we have more than that. I would like now to turn to the commercial activities exception.
Can I just have one more question about
Yes.
this one? There is an argument raised, and you certainly have had some answers to it, that these officials didn't have the authority to waive sovereign immunity. For something to be clear and ambiguous, do we have to know also that it was made by someone who has authority? I could give you a clear and ambiguous statement right now. I, on behalf of the Republic of Iraq, waive their sovereign immunity from a lawsuit for you. That's clear and unambiguous wording. But I don't have the authority. Is part of our clear and unambiguous inquiry whether we also have to find that it's a statement made by someone with authority?
Yes, Your Honor, but the magistrate judge analyzed that issue, determined that the evidence that we put forward on those Iraqi officials' authority, the experts that we produced, were sufficient. The district court never commented on that evidence. And so I would submit that that is a question that would still require a remand for the district court to consider.
So we couldn't decide today whether there was a clear and unambiguous waiver here. The most we could do is decide, if we decide in your favor, is that these statements, if made with authority, would be a clear and unambiguous waiver of sovereign immunity.
Yes, Your Honor, you would be able to decide that if those statements made
But we
with
still have to
authority.
remand. It still wouldn't be a waiver. You'd have to go back and have the district court resolve the authority issue.
Your Honor, that issue was just never, it was waived. Sorry. That issue just was not addressed by the court. So yes. Now, in terms of the commercial activities exception, the lower court erred in its analysis because it strayed from the text of the FSIA and it relied on an erroneous interpretation of the Supreme Court decisions in Nelson and in Sachs. The FSIA allows for 3 different ways of finding a commercial activity exception. Nassif and Partners is proceeding under the 3rd prong. In that prong, it says that a foreign state shall not be immune from the jurisdiction of courts of the United States or of the states in any case in which the action is based upon an act outside the territory of the United States in connection with a commercial activity of the foreign state elsewhere, and that act causes a direct effect in the United States. Now, even prior to Nelson and Sachs, the Second Circuit has been deciding judgment enforcement actions. This issue of whether commercial exception applies in judgment enforcement actions simply by relying on the text of the FSIA, and has been looking at the facts of the underlying lawsuit that led to the judgment enforcement action.
This is not enforcement. This is a recognition action.
Or judgment recognition action.
Those are different things.
Understood, Your Honor. But the Second Circuit has still just been looking at the facts underlying the merits of the case that led to the judgment.
So you have to have one waiver of sovereign immunity for the so-called the merits litigation, a separate one for enforcement actions. Do you know what the rule is for recognition actions? Does the merits action one cover that recognition proceeding, or do you need a separate waiver of sovereign immunity for the recognition proceeding?
Your Honor, I have not read any case law. I don't know that there is any cases that say a recognition action is treated any different from an enforcement action. I would submit to the court.
So you say you need to meet the enforcement action standard for this case? I thought you were relying on what I call the merit stage, the explicit waiver provision of the FSIA, which is the merit stage waiver. There's just this different section of the FSIA governing enforcement actions.
Your Honor, I'm sorry, maybe I'm misunderstanding the question. We're relying on 2 separate exceptions. We're saying Iraq explicitly waived, and then we're also saying there was also a commercial activity exception because the conduct of Iraq was a commercial activity, the relevant conduct to this recognition action. And so.
Sorry, but the FSIA has section 1610 governs immunity from enforcement actions.
Under
1610 is a different test than the explicit waiver language that you're relying on. Or
I'm relying on 1605A2.
Okay, that doesn't cover enforcement actions.
Recognition actions. Sorry.
Okay. Sorry. Yes. Well, that's my question to you is, does that govern recognition? Do we group recognition? I thought your answer to me was we put that in the camp of enforcement actions. Because I said, is it part of the merits or is it part of the enforcement? I thought you said it's enforcement.
Oh, I'm sorry, Your Honor. Maybe I misunderstood my question there. What we're saying is this recognition action, the commercial activity exception is governed under A2. So a recognition action under A2 we could still have an explicit waiver based on a commercial activity.
Okay. Are you aware of any cases that talk about which of the two waiver routes covers recognition actions?
Well, Your Honor, the FSIA just says that if there is an action where there is a commercial activity based on a commercial activity in the United States, then the sovereign is deemed to have waived his immunity. So in a recognition action, if the action is based upon commercial activity, then there would be a finding of it, provided that there's a direct effect in the United States, there would be a finding of explicit waiver. And with the issue with the recognition action is that there's already a pre-existing judgment, right? So do we look at the underlying merits? Do we look at the underlying facts? Or is it just we're looking at the elements of a recognition action? What the court did here is just look at the elements of the recognition action. And we submit that that is incorrect, given what Sachs and Nelson have already explained, which is you don't look, when you're determining whether commercial activity exception applies, you don't look at the elements of the case, even though Nelson did do that. What Nelson taught is you look at how is the sovereign acting? Is he acting as a sovereign or is he acting as a private party? And in doing that, Sachs explains what Nelson really did is look at the core of the suit and phrases the question as, what did Saudi Arabia do to injure the plaintiff in Nelson? Was it recruiting Nelson to come and work in Saudi Arabia, or was it torture? And the torture is a sovereign act. Sachs then criticizes the Ninth Circuit for having applied a one element test and says, again, that's not what Nelson taught. Nelson says we look at the core of the suit. What did Saudi Arabia do wrong? Here, what did Iraq do wrong? If it is failing to pay a judgment, that is commercial activity. The failure to pay a debt is commercial activity.
Okay.
And sorry.
I'll let you wrap up here.
Yes.
I think
And did it,
argument from your briefs.
thank you. Did it have a direct effect in the United States? It most certainly did, because Iraq was the one who decided that that debt would be paid with urea and sulfur, because the debt was $53 million. It required tons and tons of urea and sulfur, and the only available buyer was in the United States. And that is in the record at Appendix A270.
Thank you.
Thank you.
We'll give you a couple minutes on rebuttal.
Thank you.
Morning, Your Honors. May it please the court, Faisal Zuberi on behalf of the defendants and appellees, Republic of Iraq and its Ministry of Industry and Minerals. This is a lawsuit seeking the enforcement of a Jordanian judgment that the Jordanian appellate court itself refused to enforce on sovereign immunity grounds. The district court correctly dismissed for both.
Was that I'm not really sure of the procedural posture in Jordan, because there's something in the plaintiff's brief that says it was a court of cessation or cassation affirmed the judgment of the lower Jordanian court. And then the next thing I hear is that the Court of Appeals for Jordan decided that sovereign immunity barred the enforcement. Can you clear that up for me? I don't understand it.
Yes, that is correct, Your Honor. So there was a Jordanian trial court ruling on the breach of contract case. That ruling was appealed up to the Court of Cassation, which affirmed that there was a breach of contract and issued a judgment.
And in neither one of those proceedings was sovereign immunity invoked?
That's correct. And the district court notes in its ruling that the reason they found there was no immunity is because the ministry participated in the case, presumably without asserting immunity in that case. However, when they filed a subsequent judgment enforcement action in Jordan, the Court of Appeal in Jordan held that there was no explicit waiver of sovereign immunity. So appellants were unsuccessful in seeking to enforce the judgment in Jordan before they came to the United States and are seeking to enforce that same judgment here.
You're not arguing that there is no judgment to enforce given the Jordanian Court of Appeals decision. I mean, I wonder why. But, if the judgment is unenforceable or invalid because there's sovereign immunity, then where's the judgment that they're trying to enforce?
We agree that ruling should basically be res judicata and collateral estoppel on this judgment enforcement action under principles of comity. And that's one of our alternative arguments for why there's no explicit waiver here, Your Honor.
Yeah, I wouldn't put it in those terms, though. Not comedy and res judicata, but simply there's no judgment to enforce because the Jordanian courts have held that it's invalid.
Yeah, we would not disagree with that characterization. The district court here.
Sorry, I'm more confused. So the Court of Cassation found a waiver of immunity on commercial activity. That's Appendix 10789. It was then a different court. A different court later, see the Amman Court of Appeal enforcement decision that said you can't enforce it.
Correct.
I thought you just said that I thought you just told Judge Randolph that the Court of Cassation did not affirm the judgment,
No.
did not address sovereign immunity.
That's incorrect. Like they found a waiver of immunity, but not because there was an explicit waiver of sovereign immunity.
But they found it under commercial activity.
There's a commercial activity between Iraq and Jordan. They may have concluded that, but they also noted.
Wait. So
Yeah.
there is a judgment.
There is a judgment on a breach of contract claim, yes.
There is a judgment.
There's a
Court
judgment.
of Cassation, is that the highest court in Jordan?
I believe so, yeah, that's the
Okay,
highest
so the
court.
highest court in Jordan has said there's a judgment here and your claims of sovereign immunity are rejected because this was a commercial activity.
No,
Whatever their test is for that. But
yeah, so I think there's two parts in the Court of Cassation, and I think the district court recounts this in its ruling as well. It's number one, there may have been a commercial activity between Iraq and Jordan, but number two, I think they also mentioned that because the party participated in the litigation, there was no assertion of sovereign immunity at the trial court level. So I think that basically the breach of contract
Among the
action.
normal acts that are subject to the private law, there's no way to use the jurisdictional immunity considering the nature of the commercial dealing between the plaintiff and the defendant. That's 109.
So
The
that,
decision from the Amman court was only about enforcement,
That's
not about
correct.
the existence of a valid judgment.
that is correct. It's about the enforcement.
And this is not an enforcement action. This is a recognition action.
Well, it's a recognition action, but it's seeking to enforce that same Jordanian judgment.
So if the district court recognized this judgment, would that lead to automatic enforcement or would they have to file an enforcement action wherever they find assets?
Yeah, they would have to seek
Okay, so this is
enforcement.
not an enforcement proceeding.
Okay.
I'm just asking,
Yeah.
it's not. There has to be a whole nother proceeding. No enforcement would result from a judgment in this case, recognizing this judgment, correct?
Correct.
Okay.
So the district court in this case correctly concluded that there is no subject matter jurisdiction under the Foreign Sovereign Immunities Act, either under the commercial activity or the explicit waiver exception. Appellant all but conceded that the commercial activity exception couldn't apply when it chose not to object to the magistrate judge's original ruling. However, since the district court also correctly ruled that there was no explicit waiver, appellant now contends that the third clause of the commercial activity exception should apply to this case. There are, however, two insurmountable hurdles to the application of the commercial activity exception, which I'll address quickly before then moving on to the explicit waiver. With respect to the commercial activity exception, number one, this case is based on a Jordanian judgment. Per the OBB versus Sachs and Nelson versus Saudi Arabia decisions from the Supreme Court, the based upon analysis focuses on the gravamen of the complaint by reference to the elements that are required to prove up the plaintiff's claims. This court in Odiambo versus Kenya confirmed that the same interpretation of the based upon analysis applies to the second clause of the commercial activity exception because the same phrase and the same statute should be interpreted the same. And most recently, or even more recent than the Kenya decision in Colombia versus Tanzania, this court affirmed a district court ruling that applied the same interpretation of the based upon language to the third clause of the commercial activity that the appellant is trying to invoke here. And it did so in substantially similar circumstances, concluding that the case was that the case seeking the recognition of a foreign judgment under the same DC Uniform Money Judgment Recognition Act was based upon a foreign judgment as opposed to any underlying commercial activity. Well, yeah.
So since this is recognition and not enforcement, and it's recognition, I assume, under the DC Uniform Foreign Judgment Act, And since the recognition proceeding requires looking at the underlying proceeding, I mean, this is just sort of to enter a judgment in this court that is equivalent to the judgment that was entered in Jordan. It requires looking at the proceeding, some of the nature of the content of what the dispute was about. I don't know that it's enough to say this is based upon that judgment, because that judgment itself, one, is a reflection of a particular dispute, but more importantly, the recognition action itself requires examination of content and procedures of that prior, how that judgment came into being. So I'm not sure you can say it doesn't look at what the nature of the dispute was, what the character of the dispute was, how the procedures were involved, whether the other court had jurisdiction, whether there was fraud, whether there's a conflict with another judgment. There's just a lot of factors that you have to consider. So it seems to me difficult to divorce it the way you do. I'm not talking about an enforcement action. I'm talking about a recognition action. To pretend that that's totally divorced from the underlying proceeding, it's actually really kind of like just a continuation of another proceeding.
So in Colombia, the court dealt with a similar judgment in recognition action, not an enforcement action. And it concluded that the action was based upon the foreign judgment as opposed to the commercial activity underlying the foreign judgment. And I think that's the distinction. In terms of a judgment recognition action, this court or the district court would have looked at whether the foreign court had jurisdiction, whether the court had due process, whether there's a fully enforceable judgment, but it wouldn't need to look at what was the commercial relationship between the parties, or what did the contract require. Specifically, like in this court's own Colombia ruling at page 1143, this court was focused on the judgment itself, concluding that, quote, this case involves no remedy of specific performance or immediate consequence in the U.S. flowing from the Tanzanian judgment, so there is no direct effect here. Much like the judgment in Colombia, the judgment in this case, which is on appendix page A860, does not require any performance or payment in or to the U.S. So I would submit that the judgment recognition action, what's relevant are the elements that are required to prove up the plaintiff's claims. And those elements are, whether the court had jurisdiction, whether there's due process, whether there was a foreign judgment. But I don't think that the commercial relationship between the parties is, however, relevant. Even assuming that it was relevant.
What if the defendants, if you guys had in this proceeding, wanted to raise one of the factors recognized by this code stat, the Uniform Enforcement of Foreign Judgments Act? What would, say you wanted to raise, there's a conflicting decision, there was fraud in the proceeding. What if you wanted to raise that this was really a tax dispute, not a commercial dispute, that you're trying to resolve some tax disputes with them? What would happen then?
I'm not sure we could relitigate the original judgment. I mean, we could argue that it's not enforceable.
You can't, this is a standard for recognition under DC law of this judgment. Surely, if you thought it was obtained by fraud, if you thought that it was contrary to some agreement, a settlement agreement in the case, if there was insufficient notice, if there were two other proceedings going on that this was in conflict with, you're saying you couldn't raise those defenses?
You could raise those defenses, but I don't think they necessarily require an examination of the contractual relationship between the parties, right?
No, but
they're focused on
certainly there's categorical exceptions for certain types of civil actions. If this was a tax, if Iraq's defense was that this wasn't to settle a contract, it was to settle the taxes that they had overpaid to us. What would happen then?
I mean, I don't think we're faced with that scenario, nor have I seen case law addressing it, but the case law I have seen from this circuit.
Then you'd have to examine the underlying judgment in order to enforce the judgment.
You would examine
the judgment.
You would examine the judgment, but you don't necessarily have to examine the contract that the original judgment was based upon. I mean, so like in the Supreme Court in OBB versus Sachs, for example, it was a personal injury lawsuit for someone who purchased a train ticket in the US. And the Supreme Court said, based upon analysis, we're not going to consider the fact that the train ticket was purchased in the US. Rather, what's relevant is that this person was injured while they were traveling
Yeah,
abroad,
I think
right?
that's very different from the point that I'm raising.
Okay. I mean, even if we were required to examine the commercial activity underlying the Jordanian judgment here, what we have here is a contract between a Jordanian plaintiff and an Iraqi government entity for the delivery of chemicals in Jordan. There was no performance or payment required in the US in this case. So there could still be no there could be no direct effect from any commercial conduct that was underlying the Jordanian judgment. Even if we had to examine what the Jordanian judgment was based upon, we would submit that there's no direct effect of any conduct in Iraq, any commercial conduct in Iraq between the parties that would have an impact in the US. In fact, in the Odhiambo versus Kenya decision, this court noted that the rule is that by definition, quote, breaching a contract that establishes the United States as a place of performance will have a direct effect here, whereas breaching a contract that establishes a different or unspecified place of performance can affect the United States only indirectly as a result of some other intervening event. I think appellant's reply brief acknowledges that there was no requirement to ship on part of Iraq these materials to the US. Iraq could not agree to do so because it was subject to US sanctions at the time. The Jordanian judgment itself, the one that they're trying to recognize here, which is at appendix page 849, paragraph 4, notes that this was a contract between a Jordanian plaintiff and an Iraqi government entity for the delivery of chemicals in Jordan by exporting them via the Iraqi-Jordanian borders pursuant to the letter of a commitment.
I know you want to discuss waiver and you've got less than.
Sure.
I have
Sure.
some questions about the explicit waiver here. I mean, so Iraq does not dispute the statements that were made in the declaration. Is that correct?
What-
Or did not below or
No,
does not here dispute that those statements were made?
I don't think we don't dispute that they were made, but we didn't see a need to dispute them in the district court because they're insufficient. And I mean, they're decades old statements.
Dispute their description of the words?
We're not in a position to dispute or not dispute them because the people who supposedly made them are dead or gone, right? That's the practical situation.
So if you're not disputing them, and then, I mean, why shouldn't we look at that declaration and see that looking at all of the statements together, Iraq had an intent to waive its sovereign immunity?
I mean, number one, they're paraphrased oral hearsay statements that seek to recreate conversations that took place 10 years ago.
You're not disputing the.
Disputing.
Sorry, go ahead.
Yeah, sorry, yeah.
You're not disputing that. If you were disputing the content because it's 10-year-old here, excuse me, is 10-year-old hearsay, I think we both have the same question here. But if you're taking as given that those are accurate statements as to what was told them, then you need to answer Judge Rao's question.
Even if we assume that they're accurate statements, they're insufficient to clearly, unequivocally, and unambiguously waive sovereign immunity in this case. None of them mention sovereignty, immunity, waiver. None of them even discuss those concepts.
It has to be clear and unambiguous, but the court has also said that it's not a magic words requirement, right? And there's statements in the declaration like Iraq would not and could not dispute the lawsuit at all. Iraq and the ministry, would have no defense to any such lawsuit.
Our position is that even if those statements were made, they would be statements about the merits of the dispute. None of them say that Iraq is not going to object to the jurisdiction of the court in the United States. Even an implicit
Sovereign
waiver.
immunity a defense?
Yes.
Affirmative defense.
Yes. It's not, yes.
It's an affirmative defense.
It's a defense. Yep.
I mean, it's jurisdictional here, so it's more complicated, but it's.
What
I mean, it's
if
yours
they
to wait
said,
for that.
I'm
Go
sorry,
ahead.
what if the statements were, on behalf of the government of Iraq, I hereby waive sovereign immunity?
That would be clear and unequivocal.
It would be, but it would be out of court, not sworn. And then the next day, the plaintiff comes in and sues, and the counsel for Iraq invokes sovereign immunity. I don't see why an oral statement ahead of time would be binding at all.
I agree with that, right? So there's two problems with their waiver argument. Number one, the statements are not a clear and unambiguous waiver of sovereign immunity. Number two, they're not verbatim and they're not contemporaneous. And,
Hang on.
mhm.
You said verbatim and contemporaneous are not relevant to you because you're accepting for purposes of this motion that these are actual accurate descriptions of the words.
If they are, they're insufficient. But what we alternatively also argued that there's no case that allows for an oral waiver of sovereign immunity at all.
Is there a
And
case that says there can't be?
there isn't a case that says there can't be,
If
but
you have an oral contract?
no, there's a written contract, a letter
Can you have-
agreement.
I'm sorry, my question was, can you have oral contracts?
Yes,
Okay, can sovereigns have oral contracts?
yes, but there would have to be
If there's a-
consideration.
Yeah.
Yeah.
I said there's a contract, all right? I'm not here to go through all the elements of forming a contract. You've agreed that a sovereign could enter into an oral contract. Sometimes in contracts, sovereign waives immunity right in the contract itself.
That language is not there in any of these statements.
I'm
Mhm.
gonna finish here.
Sure.
You just made a very broad statement that it can never be oral. If you have an
So-
oral contract in which the sovereign orally, with full authority, says, as part of this contract, if a dispute arises, the Republic of Rock hereby waives its sovereign immunity from suit on that contract. And you had all the evidence you need, an oral contract is found, the terms are not disputed as they aren't here. Your position is that you can't have an oral waiver of sovereign immunity?
So I'll explain why I think you
Is that a
should.
yes or no question? Could that be, is that your position, that oral waiver of sovereign immunity, undisputed in content, undisputed in authority?
Contemporaneously recorded and verbatim.
Again, things you aren't disputing in this case. I don't know why you keep repeating that. I am giving you the facts as I've given them.
Mhm.
Would that suffice?
I mean, you would have to have the context, which we don't here.
I told you the context.
So,
Is your position there could never be an oral? I heard
I-
you say never be an oral waiver. of
so
sovereign
there
immunity.
never has been, right? There never has been
That's-
recognized in the case
okay,
law.
That's why we get
And-
paid to
and-
decide these things.
And then the legislative history of the FSIA, I think, is relevant to that question. So for example, this court has found that there can only be an implicit waiver in the three circumstances recited by the
What's
legislative history.
implicit about an express
So
oral waiver?
it's not implicit, but that same legislative history also recounts only two examples where you can have an explicit waiver. Number one, treaty. Number two, contract. So that's why we submit that ex post facto oral statements that are neither a treaty or neither a contract should not be sufficient to waive oral immunity.
I'm sorry, if they brought the former president of Iraq to the stand, and he said, yes, on behalf of Iraq, I orally waive sovereign immunity.
If he were on the stand and he said that,
It's an oral, it's still oral.
it's still oral, right? But the circumstances would be completely different. This is not, for example.
Those are different I'm responding to your argument that there can never be an oral waiver of sovereign immunity because we don't have a case yet.
We don't know what words were even used here, right? So that's part
Not
of the
disputing
difficulty.
the words. You can't say that. We know what words. They've told us the words and you're not disputing.
So even assuming the truth of their words, our position is that they're insufficient to waive sovereign immunity because none of them talk about sovereign immunity. None of them talk about jurisdiction. They don't use the words, we're not going to object, or we're not going to object to the jurisdiction of this court.
We'll raise no defense.
Correct. And that could be.
We will raise no defense. And you just agreed that sovereign immunity is a defense.
It would have to be more specific than that. The waiver
Why
has to be.
Is that if I'm not sure what's ambiguous about. We have rights. We're aware of those rights. We hereby knowingly, intelligently, with authority, represent to you that we will not raise any of those defenses.
I don't
That's
think.
not clear and unambiguous.
I don't think those sentences are that clear and unambiguous. And I mean, there is a case that we cite in our brief which found an explicit written waiver of sovereign immunity, which explicitly said, we hereby waive sovereign immunity insufficient because the immediately preceding paragraph said that that agreement was going to be governed by Guyanese law, right? So the problem here is we're completely devoid of the requisite context. We don't know what other discussions happened here. That's the,
I think,
Mhm.
sorry, unless, do you have any questions? Okay, you can sum up her, I cut you mid-sentence there, sum up your sentence, and then I think we've heard your argument.
sure. Our position is that there isn't a specific and clear unambiguous waiver of sovereign immunity here. In fact, many of the statements recount that the officials didn't state that there was sovereign immunity. Therefore, this court should imply or by implication find some sort of waiver. We would submit that the evidence and the statements themselves are entirely insufficient.
Okay,
Plaintiff must come forward with something to show that sovereign immunity was waived, and they haven't done so here.
okay, thank you.
Thank you.
Okay, Ms. Ortega Gomez, we will give you 2 minutes.
Your Honor, there was a direct effect in the United States as a result of Iraq's failure to deliver the urea and the sulfur. And we know that because in the record at A204, the declarant says that the inability to fulfill the New York buyer devastated our company's reputation in the marketplace, materially compromised our access to the commercial department of the U.S. Embassy in Amman, Jordan, and thwarted our ability to meet financial obligations. They essentially got blacklisted. Nassif and partners got blacklisted by the commercial department of the U.S. Embassy in Amman because the urea and sulfur never made it to the United States. Now, Odiambo, this court in IG Energy Fund recognizes that in Odiambo, there was a concern over plaintiffs unilaterally creating U.S. jurisdiction. Because in Odiambo, the plaintiff just moved to the United States and said, well, I live here now, so this is where I'm supposed to get paid the reward money in that case. That is not a concern in this case because it was Iraq who decided to pay the debt using tons and tons of sulfur and urea. It was $52 million worth of urea. And at that time, our record also shows, at that time, there was no other buyer in existence other than in the United States. So Iraq was the one who caused the direct effect who involved the United States in this lawsuit. And we know that this direct effect wasn't trivial because the U.S. Embassy in Amman isn't going to just blacklist a person in the marketplace because they failed to deliver a product that they consider to be trivial. Thank you.
Thank you very much, counsel. The case is submitted.
This order of the federal offender to have himself, who paid the 130 jail.